On behalf of Mr. Johnson, who's present, standing to my right.
This is set for a status conference today, Mr. Vernon. How did your side?
My client is going to enter a plea. We were able to work out the details on that. The agreement was that he would enter a plea to the drunk driving third, dismissal of the remaining counts. The matter would be transferred to Cadillac for sobriety court. Sorry, Clark, for sobriety court. On completion, successful completion of sobriety court, it will be reduced down to a drunk driving second, operating while visibly impaired second.
That's correct.
It's been reduced to writing and provided to the court.
Okay. Mr. Johnson, have you had a chance to talk to Mr. Vernon about this plea agreement?
Yes, Your Honor.
Is that how you want to proceed today?
Yes, Your Honor.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Okay. Mr. Johnson, are you currently on any kind of probation or parole?
No, Your Honor.
And do you understand that if you were to fail to successfully complete probation or the sobriety court program, that the maximum possible penalty you could face for operating while intoxicated as a third offense is up to 5 years in prison and or a $5,000 fine? That penalty in mind, what is it?
Plead guilty to complete my sobriety court in Clare County to get it reduced down to the second and maximum up to 1 year.
Okay.
Yeah.
I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving all of those rights?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
This happened back on January 17th of 2024. Is that the correct date?
Yes, Your Honor.
Okay. On that date, had you been consuming alcohol?
Yes, Your Honor.
And after you consumed alcohol, did you operate a vehicle on County Road 612 here in Crawford?
Yes, Your Honor.
And did you have any blood or breath tests to determine the level of alcohol in your system?
Yes, Your Honor.
Do you remember what that result was?
There's a 0.2.
Do you have any reason to doubt the accuracy of that result?
No, Your Honor.
Had you consumed enough alcohol that your ability to safely and normally operate that vehicle was it prevented you from being able to safely and normally operate that vehicle? Okay. Had you previously been convicted of operating while intoxicated back in 2013 in the 63rd District Court?
Yes, Your Honor.
And then also in 2015 in that same court, is that correct?
Yes, Your Honor.
Ms. Coker, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Burton?
We are likewise satisfied.
Ms. Coker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
I am likewise not aware.
Ms. Coker, are the people satisfied that the court has complied with statute and court rule in taking this plea?
The people are satisfied.
Mr. Burns?
Yes.
Mr. Johnson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You're going to meet with Mr. Haven from the probation department to set up a pre-sentence report. And then Mr. Vernon, is the sobriety court ready to go? Do we need to set this out over 2 to period of time?
Nope, everything is ready to go. As soon as sentencing takes place, they will take over.
Okay,
But sentencing is scheduled to take place here and then transferred to Clare County.
okay, and I see we've already signed the transfers.
We got all that paperwork organized.
Okay, very good. Anything further on this case today? Oh,
No, Your Honor.
There is a show cause.
oh,
We'd appreciate it if you would dismiss it. I want to go to your attention.
the case not failure.
Yes, at the last hearing, we appeared and Mr. Johnson did not. I contacted him by phone here in the courtroom. And identified to the court that he was confused as to the time of the event. We had adjourned this matter and the original date or the original time for the scheduled hearing was at 3:15. We adjourned it to 10:30 a.m. He misunderstood when we sent him a copy of that order that the time had changed as well as the date. So he was ready to appear at 3:15, and when we called him at 10:30, he was ready to leave, but had not yet left, and it was a couple of hour drive, so you decided to conduct this. A client would have relied on those facts as his explanation for why he wasn't here.
Okay, Mr. Johnson obviously has appeared today. He's accepted a plea. It appears that he's been accepted into the Clare County Treatment Court. I don't have any information that there have been other bond violations or failures to appear. So based on those facts, the court will dismiss the show cause. And Mr. Johnson's just important, of course, to follow through with whatever Clare County is asking you to do, and that you comply with the pre-sentence procedure here. Okay.
Yes, Your Honor.
Thank you. Mr. Haven.
Judge, if I may, I wanted to let you know that I dropped a sort of a bomb on Mr. Nichols this morning. He's going over that with his client. If you could give us, I don't know, another 20 minutes or so, I think it'd be way more efficient for us all.
Okay.
Thank you.
Thank you. All right, People versus Kuhn, case number 235256. Mr. Kuhn, if you can come up to the podium, please.
Sierra Coke on behalf of the people.
Oh, yeah.
You able to hear me okay, Mr. Kuhn? Are you able to hear me okay?
I can now.
Okay. Great. This is the date and time set for a sentencing hearing in this case. Mr. Kuhn, you're appearing without a lawyer today, is that correct?
Yes.
You understand that you do have the right to have an attorney?
You're on special appearance, so
You understand that you have the right to have an attorney?
I'm here on special appearance, sir.
I know, I'm asking you a question.
And I'm here on special appearance.
Do you understand that you have the right to have an attorney?
I'm here on special appearance.
That's not my question. Are you gonna answer my question?
I'm here on special appearance, sir. You know, I understand I made a mistake and I'm ready to, try to solve this problem.
Are you gonna answer my question?
I'm here on special appearance. I'm that's all I can say.
So you're not gonna answer my question?
I'm here on special appearance, sir.
Okay, I'm gonna have you sit back over there for a minute. We're gonna take up your case again. In a little bit, I need to decide how we're gonna proceed if you're gonna refuse to answer any questions here today, okay? Nope, you're not handing anything to anybody. You're gonna go sit right over there. Okay, officer. Let's take a short recess. I don't think Mr. Thompson's here yet for Mr. Ackerman's case. Take a short break and we'll be back on the record.
Oh, Mr. Thompson is here. I'm not sure where he's at. Want me to look for him?
Yeah, he's right outside.
He was in here.
Oh.
I don't know where he is.
Okay.
He's back and forth between the two courts, but he's not either.
We're on the record in People versus Travis Ackerman. We have 3 files set for hearing today: 23532, 45311, 45312. The record should reflect Mr. Ackerman's present here in the courtroom today. I could have counsel with your permissions.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Combs on behalf of defendant Travis Scott Ackerman. Your Honor, we appreciate the court getting us in today, and I just finished up the Otsego, so I was here at 9:15. But we have 3 proposed pleas on 3 different files that would resolve all of Mr. Ackerman's pending matters before the court, including one that's on the trial docket, 2 that are brand new to the court.
Okay. And so just to make a record of the offers in file number 235232, the offer is for Mr. Ackerman to plead guilty to 1 count of resisting or obstructing, and all other charges and enhancements in that file would be dismissed.
That is an accurate statement.
Ms. Coe.
It is an accurate statement.
And Mr. Ackerman, is that your understanding as to that file?
Yes, sir.
Then file 245311, the offer is for Mr. Ackerman to plead guilty to 1 count of use of methamphetamine, and all other charges and enhancements in that file to be dismissed. Is that correct, Mr. Thompson?
Yes.
Ms. Coe.
Yes.
And Mr. Ackerman, is that the agreement that you've discussed with Mr. Thompson as to that file?
Yes, Your Honor.
And then finally, in file 245312, the offer is for Mr. Ackerman to plead guilty to 1 count of possession of methamphetamine, and in that file, all other charges and enhancements. Perhaps. And another file out there?
No. I
No.
believe that's 3 files, and that's the accurate number, Your Honor. Thank you.
And Mr. Ackerman, as to that file, is that your understanding as well?
Yes, Your Honor.
Okay. Do you need any more time to talk to Mr. Thompson about any of these agreements?
No, sir.
And is it your intention to enter into those agreements here today?
Yes, sir.
Please solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. Ackerman, are you currently on any kind of probation or parole?
I'm currently doing pre-trial services, but not probation or parole.
And Thompson, I'm assuming that Mr. Bond files.
That is correct, Your Honor. There is a bond consideration to the last 2 files, which would make it discretionary consecutive.
Okay, so Mr. Ackerman, you understand that because you were on bond when the 2 newer files occurred, that the court has the option of sentencing consecutively, in other words, back to back, with your file, but that's not something the court's required to do. And then in terms of the maximum possible penalties, I want to make sure that you understand those as well. So in file 235232, that's the case that you're going to plead guilty to 1 count of resisting or obstructing. Understand that that is a charge that carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine.
Yes, sir.
And then in file 245311, that's 1 charge of use of methamphetamine. That is a misdemeanor that carries with it a maximum penalty of 1 year and or a $2,000 fine. Do you understand that?
Yes, Your Honor.
And then finally, 1 count of possession of methamphetamine. That is a charge that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine. Do you understand that?
Yes, Your Honor.
With all of those things in mind, what is your plea to each of those charges today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand that you have all those rights?
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter these pleas today?
Yes, sir.
And are you pleading guilty to each of these charges because you are in fact guilty?
Yes, sir.
Starting with the oldest case first, that's the R&O charge. That, according to the information, occurred back about a year ago, back on June 14th of 2023. Recall that?
Yes, sir.
On that date, were you here in Crawford County?
Yes, I was.
Did you come into contact with a deputy here from Crawford County Sheriff's Department?
Yes, I did.
And at the time that you interacted with that deputy, was the deputy wearing his uniform?
Yes, he was.
And were you aware that that interaction, he was acting in his capacity as a police officer?
Yes, sir.
And was this a physical altercation, or did you reduce to comply with some commands, or what was the basis?
I believe that I just refused to comply with commands. This is the reason for the resisting, yes.
Okay. And were they lawful orders that the police officer was giving you at the time?
Yes, Your Honor.
Okay. All right. Ms. Coe, do you have any further questions as to that charge?
No, Your Honor.
Mr. Thompson?
Those orders are from Deputy Scott Clark.
Yes.
No further questions.
And then file 245311, that. That's newer, okay. File 245312, and that's the possession of methamphetamine charge. The information indicates that that was on March 20th of this year. Is that correct?
Yes, Your Honor.
On that date, were you also here in Crawford County?
Yes.
And while you were here in Crawford County on that day, did you have possession of some methamphetamine?
Yes, sir, I did.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to have any amount of that at that time?
No, sir.
Then finally, the last incident, I have it June 6th of 2024, is that correct? Just about a month ago?
Yes, sir.
Okay. And at that time, were you also here in Crawford County?
Yes, sir.
And I think on that one, we take the factual basis to the possession to support the use charge, Your Honor.
Okay. On that date, did you also have possession of some methamphetamine?
I believe I did in my person, like.
You had used it on that day,
No, it wasn't on that day that I
Okay.
used it.
but you had some of that substance in your possession at that time.
Yeah, it like inside my saliva, I guess I could say. I mean, I didn't have it on me.
Can I ask a couple follow-up?
Sure.
All right. June 6th is the day you got arrested, coming into court.
Yes.
Did you have methamphetamine within your possession? on
Yes.
that day?
Yes, I did.
All right, no further questions.
Ms. Coker, are you satisfied with the factual basis?
Yes.
Ms. Coker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Thompson, are you?
No, Your Honor, that's a complete statement.
Ms. Coker, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Thompson, are you?
Yes, Your Honor.
Okay, Mr. Ackerman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to all three. We'll set this matter for a sentencing hearing. At the probation department for a recent report. Probation wants to address any files today.
No, thank you.
Yes, Your Honor. Mr. Ackerman is sitting. He is actively working to get himself in rehabilitation. He has secured a bed at ATS. And they just need court authorization to sort of finalize that. he is interested in attending inpatient rehabilitation. He's been in for approximately a month. I think it's 29 or 30 days today. We asked the court to consider authorizing a release to rehabilitation either today or I understand the court still has discretion to as part of the sentence. I want the court to be aware of that and consider authorizing his release today to attend that rehabilitation.
So I think we need to get through the sentencing hearing, Mr. Ackerman.
Yes, John.
But if your guidelines call for a local sanction, I need to get all the other information in the report, but I think probably could benefit from. I don't have an objection as I sit here today to making that part of the sentence. Yeah, as long as you sort this out.
Yeah, I score as a straddle cell, so I that's what we're working towards.
Okay, so, yeah, I mean, I need to see all the information in that report, and I can't make any guarantees sitting here today without knowing your full situation. But I generally, if it's appropriate, given all the other potential sanctions, I don't have an objection to that. Because I think just based on the charges, and I don't know much about your background yet until I get that report. Just based on the nature of the charges. So here to maybe.
Thank you.
Your Honor, can I confirm all of his bonds are revoked, right? So he's getting credit in all 3 files?
I believe one's revoked and, well,
The 2-3 file is definitely revoked. I don't know
Yeah.
about the other two.
the second one was revoked and the third one was just never posted.
Okay, I just want to make sure he was getting credit. Thank you.
Thank you.
Sure.
Thank you. All right, we're separate. Thank you.
Vernon, you're that's a civil matter, right?
Yes, yeah, change
When is that?
directions for you a little bit. It's scheduled for 9:30. My client is here. The opposing party is not, but I wasn't sure if he was going to appear by Zoom or not.
Yeah, I do have somebody in the.
If he's here, you can stay there. So what's happening on that?
I don't know.
I will tell the court that I've had difficulty getting hold of Mr. Gray, so I'm not sure what his intention is.
Seriously.
Um,
Johnson.
Johnson, Ackerman are done. You only have Cooney started it and then.
I have somebody connected here, sir, or whoever that is. Can you tell me your name, please?
Robert Gray.
Mr. Gray, okay. So we'll go on the record. This is Sherry Marker Gray versus Robert Gray. This is case number 2311522. We have Ms. Gray with her counsel here present in the courtroom. Mr. Gray is connected by Zoom. Mr. Vernon, this is your motion to set aside a mediation agreement and consent judgment that was entered in this case. I did review the basis for your request, so I kind of understand what's gone on since the judgment was entered. Is there anything else that you wanted to say?
I've had several conversations with Mr. Gray. It is clear that the federal government is not willing to accept the consent judgment as it was entered for the purposes of releasing the lien on the home so that it could be sold. So all the things that were outlined in the judgment of divorce could be accomplished. So what we're asking the court to do is set that aside. I've had, again, some conversations with Mr. Gray, some exchanged emails. I think we have a new framework that might satisfy the federal government and their restitution claims, but we won't know until we submit that to them, and that has not yet been done. We had scheduled a meeting a couple of weeks ago with Mr. Gray and Mrs. Gray, in my office. Mr. Gray did not appear, so we were unable to accomplish that. Mr. Gray did send me an email with what he had hoped the language in the judgment would be. We haven't finalized that. We haven't sent it to the attorney covering that matter for the federal government. So, I mean, at this point, I think we're close, but there's a whole lot of dominoes that could break this thing up.
Okay, Mr. Gray, do you understand why we're here today?
Yes, because either it was a clerical error or it was a deliberate action to not do what we all agreed upon in the courtroom. It was very simple. We made a bundle package, so Mrs. Gray would get the money from stuff we sold, my $23,000 back in the deposit that we were going to use to pay off the side-by-side and pay off my half of the credit card. It was put in the bundle. The bundle was supposed to be $87,250, but when we were in Zoom, Mr. Vernon added up $85,000, which I didn't think about at the time. I don't think Sherry thought about at the time either until afterwards. So she was upset with that amount, and I agree with her. And it was in the bundle so that in the real property paragraph, all that stuff was done. The U.S. attorney was good with it. And then I didn't look at it. Mrs. Gray didn't look at it. I submitted it to the U.S. attorney, and they said, well, we're not going to we'll go side by side with the mortgage. We'll give Sherry her bundle, but after that, we're splitting it. Well, they pulled the side by side and the credit card payment out of the bundle, and the government says, we're not doing that. And that was never, I actually, Your Honor, I'm waiting for the transcripts to be sent to me. I paid to get them to show. I tried to talk to Mr. Vernon, but he won't reason with me. It was agreed upon in your courtroom that in the bundle was my $23,000 from the deposit on the house, which paid the side-by-side and the credit card. It should have never left the bundle. And because it left the bundle, the U.S. attorney said, nope, we're not doing it. And now we want it itemized. That's what happened. That's the truth. All it has to do is go back in the bundle. Whether if Sherry wants the $87,250 like she's supposed to have, I'm good with it. I'm for it. Just put the money back into the bundle and we're done. That's it. It's that simple. They took it out of the bundle and that's what happened.
Okay, Mr. Vernon.
Your Honor, I don't know whether I should argue the factual basis that he's arguing. The consent judgment was entered. The reason it was entered and signed by all the parties was because the parties thought it was a fair division of the property. The Attorney General's office refused to release the lien because the money, either in the bundle or itemized separately, was paying off debts that accrued to Mr. Gray. And they said, no, that we're first in priority as to those monies out of the sale of the home. You shouldn't be paying off an unsecured credit card or side-by-side with the money that we should be entitled to. So we have to draft this so that that money is arranged or divided differently so that the Attorney General will be satisfied that the money being the profits from the sale of the home aren't being essentially applied to lesser secured debts. That's our issue.
Your Honor, if I may.
Yeah.
Then answer the question, how come you presented it with Sherry getting $85,000 and then paying off, we would agree to pay off the side-by-side and half the credit card. Where do you come up with $85,000 at? When she pulled that $23,000 out of 85, Sherry would only get $62,000. So how could you have it both ways? The $23,000 was in the $85,000. I have Sherry's emails. She knows it. You pulled it out, and that's why we're in this situation. You're trying to blame me with some fraud crap that the court already knows why we're in the situation. So how can I be charged with fraud? We're here because somebody made a clerical error in your department. Your office does not want to admit it. If I'm wrong, then explain to me how she would now get $85,000, and then we would split the side-by-side and the credit card. Where did she get the $85,000? Because the 23 is in there. That's the honest to God's truth. You just explain to me how you come up with 85,000, and that doesn't include the side-by-side and the credit card. And then we can move on.
Okay. All right. I think what I'd like to have, Mr. Vernon, I mean, are you in communication with the AG's office or whoever?
So there is a paralegal who works for the attorney who's handling the matter, who I've been in contact with.
Okay.
I sent her the original draft of the proposed consent judgment. which she thought would be approved. She submitted it to the attorney and the attorney said no for the reasons I just stated. So certainly I have some contact with their office, but not with the attorney handling the matter.
Okay, I guess what I would like then, and I'll issue a written ruling once you can get this to me, and Mr. Gray should be copied on this as well. I'd like a written statement from.
Well, Your Honor, with all due respect, we need to sell this house. Me and her cannot afford it. Sherry's sitting there. She knows that I'm right. If all she has to do is tell him, put the side-by-side in the Polaris back in the side-by-side in the credit card, back in the 85,000, and we're done. We can sell this house. I don't want to waste my time or the court's time with something that we already agreed upon. And if we're going to do that, then I'm going to request a hearing that we can go through the transcripts from the last court case that shows that I'm right.
Okay, and you're free to do that if you'd like. I'm telling you, this is what I need to do, because you're telling me one thing, Mr. Vernon's telling me the other. And, you know, I don't have any basis to believe either of you at this point over the other. So what I'd like is a letter or some written notification from the AG's office. Mr. Vernon is either.
I already asked her.
Can you please stop interrupting me? I'm trying to make a record here, okay? I'd like to see what, you know, that's either going to be confirmed by what you're saying, Mr. Vernon, it's either going to be confirmed or it's not from the governmental entity here. So I'd like to see what they have to say about it, and then I'll issue a written opinion on your motion. If I grant it, then we'll go down one road. If we don't, then we'll go down a different road.
Would the court be satisfied with an email correspondence with the paralegal working for the attorney, or do you want something in writing more formal from the attorney?
Something formal that to be made of record. And then the court will issue an opinion.
Can I speak?
We will work on that.
Yes, go ahead.
Can I like to talk about how they charge me, they're accusing me of fraud to reopen this case, and he hasn't explained that yet.
I didn't get that anybody's accusing you of fraud. That's not the way I'm looking at it.
I looked at the document that was sent to my house, and it says that they're open this because of fraud. That's what it says on the court document.
That it was the basis of the motion. I mean, we argued that he did not disclose that there was a lien on the house due to his restitution, and that the entry of the consent judgment was based on the availability of all the funds from the sale of the home, which was not true. Once we found out that there was a lien, and that's why it was being held up. I mean, they were trying to sell it. The realtor called me and said, "Hey, there's a federal lien on this for $350,000." So yeah, that would be that's the basis of our allegation.
We talked about that in the last court case. It was everybody already knew it. So how could I be accused of fraud? I mean, I have a family and a reputation. I don't like it being dragged in the mud for something that we already discussed in the last court date. I don't think that's fair. You saying,
right,
what did I do from the last court date till now to commit fraud?
I'm just trying to get to the bottom of this so that we can get this finalized for both of you. And me getting communication from the government is going to help me do that. And that's the direction I'm going with it. If you want to, Mr. Gray, if you want to litigate their claims of fraud, you're free to do that.
The U.S. attorney said she won't give. I already asked her for what you're asking for. She said no. Just telling you, but go ahead.
That's the way we're going to go forward. I'm sorry if you don't agree with it, but that's how it's going to happen. So
what happens?
That's all. I'm going to get that communication from the government. Mr. Vernon's going to provide that to me, and then I'm going to make a written ruling about their motion to set aside the judgment of divorce and the mediation agreement.
Well, can they clarify one more time what you're going to ask the U.S. attorney?
I'm asking them to provide in writing confirmation of what Mr. Vernon has represented that they're saying.
And what is that?
Mr. Vernon?
That the Attorney General's office is refusing to release the lien because the structure of distribution of the profits from the sale of the home are going to lesser secured debts, and that they have priority over, and they want their money before the unsecured credit card and the payoff on the side-by-side.
So in a nutshell, what you guys are saying is that, I know what this is about. Sherry does not want me to have the side-by-side. So you guys are trying to get the side-by-side sold so that I don't get it. That's what this is all about. So we're wasting money that I can't afford to pay for a house that we can't put on the market for another 3 months now I can't even afford to cut the grass. It's because she doesn't want me to have the side by side. That's what it's all about. That's why you guys pulled it out of the 85,000. So we're gonna rewrite this whole divorce decree.
This is a conversation you can have with Mr. Vernon off the record. So that's all I have for today.
Thank you, Judge.
The court is going to disconnect this time.
Thank you.
Judge, Mr. Curran states he probably needs about another 5 minutes. He needs some from his office. Let's wait for a phone call.
Okay, council, we're on the record now in Walker versus Munson Healthcare. And if I could have you both put your appearances on, starting with plaintiff, please. Mr. Day, are you able to hear me?
I am, yes, Judge.
Ms. Filiatro, are you able to hear me?
Yes, I am. Good morning. Thank you.
Okay. Okay. We have both counsel connected. This is set for a scheduling conference in this case today. Excuse me. I don't think we've had any kind of conference. Well, maybe we did. Hold on. Okay, we did have a scheduling conference back in February. So this is set for a status conference here today. Ms. Filiatro, can you kind of update me on where things are at from the plaintiff's side?
Certainly, Your Honor. Good morning, Your Honor. Rebecca Filiatro appearing on behalf of the plaintiff, Tiffany Walker. We have completed the discovery, Your Honor, and all the depositions are taken, written discovery has been exchanged. I did send counsel a request to produce relative to some documents that were referenced in a deposition last week. But the parties have been working cooperatively together and have accomplished, most, if not all, of the discovery thus far. And we are scheduled to go to facilitation with William Carey on July 16th.
Okay, great. Thank you. Mr. Day, anything you wanted to add to that or anything different?
I think it's a fair summary, Judge.
Okay, so I guess I'm thinking just setting this for another status conference following your mediation to see whether that was successful, and then kind of check in with both of you to see what you'd like to do if it doesn't mediate, what you'd like to do for scheduling going forward. Ms. Filiatro, do you have any objection to that?
No, Your Honor, I think that this is a pretty straightforward premises liability case. I'm cautiously optimistic we might be able to get it resolved through the mediation process.
Okay, Mr. Day, any objection?
None. Thank you.
Okay, so the court will send out a notice of date and time of that hearing. That'll be by Zoom, just like we're doing today. And thank you. You're both free to disconnect at this time.
Thank you, Judge.
Thank you.
I think he is. I think they're coming in person. My understanding is that there is a judgment or they're going to prove some record of that case today.
Ms. Massey, are you able to hear me okay?
Yes, Your Honor.
Okay, great. We're on the record in Hall versus Hall. This is case number 2311534. We have both counsel present, Ms. Massey and her client, client by Zoom, Mr. Vernon and his client here in person. This is set for a status conference today. On behalf of Ms. Hall, Mr. Vernon, can you tell me where things are at?
We are very close to being done. We're going to ask the court to take proofs today. We have a proposed consent judgment. We have one little change. Juanita, do you have the judgment in front of you?
I do.
So what we're looking at is on page 2, striking under real property, we're looking at striking the third $26,000 payment to the defendant as an offset. We're striking that and adding into the personal property a transfer of $26,000 from her IRA to his. I believe that was a conversation your client had with mine separately, so I don't think that's an issue.
My
But we need to
client, my client did discuss that with me, and I believe that is correct. And it's going to be by Quadro, correct?
So my understanding is that they're gonna, because all of their accounts are with the same business, that they can make that transfer without any penalties or other fees or any other problems. So we can just transfer the money from her account to his without much to do about it. We're gonna confirm that before we sign it, but that's the plan.
Yeah, okay.
Yeah.
Yes, that's fine.
So other than that, the consent judgment is as drafted.
Okay.
So we're just gonna make the one change. We're gonna make one phone call to the financial advisor to confirm that those assumptions are correct.
Okay.
And then we will have a prepared consent judgment for the court. So with that understanding, we're asking the court to take some proofs today.
Okay, Ms. Massey, do you have any objection to going forward with proofs today?
No, Your Honor, but if I could just ask Mr. Vernon real quick. I guess there was an issue with the boat too, the sale of the boat. My client was supposed to get all proceeds of the boat.
That was,
Was it in there?
I didn't know if I didn't see that, so.
yes, I took half what I'm gonna do with the vote. So yes, if we can write that in there, that 26,000 that I'm giving him is the he self-vote itself.
Okay. Yes, that is my understanding, that the
Okay.
proceeds from the boat go to your client.
Okay, then we're all set.
Okay.
Okay. Ms. Hall, if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? On your hand and spread them, please, please.
Thank you. State your name, spell your last name.
Melissa Paul, H-U-L-L.
And had you lived in the state of Michigan for 180 days prior to the filing of the complaint for divorce?
Yes, I have.
Can you speak up just a little bit so it's recorded?
Yes, I have.
Thank you. And had you lived in Crawford County for at least 10 days prior to the filing of that complaint for divorce?
Yes, I have.
And when we submitted that complaint for divorce, had you read through it and signed it?
Yes.
And were all of the statements made in that complaint true at the time you signed it?
Yes.
Are all of those statements true now?
Yes.
Have you reviewed the consent judgment of divorce? Have you reviewed the consent judgment of divorce?
Yes.
And the division of property in there, do you believe that to be a fair and equitable division of the marital assets?
Yes.
You understand that one of the provisions here is a spousal support provision, which identifies that neither one of you is accepting or requesting spousal support?
Yes.
You understand that by doing so, you are forever barred from requesting spousal support in the future?
Yes.
So you understand that if he wins the lottery next week, you can't come back and ask him for more money later?
Yes.
Same goes for him, right?
Yeah.
Okay. Are you pregnant?
No.
Okay. I think we satisfied all the statutory requirements.
Thank you. Ms. Massey, did you want to take any testimony from Ms. Hall?
No, Your Honor.
Did you want to take any testimony from your client today?
Yes, Your Honor.
Mr. Hall, if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Ms. Massey, go ahead.
Thank you. Mr. Hall, you heard the questions that were asked of your wife.
Yes.
And have you read over the consent judgment of the divorce that we looked at?
Yes,
And with the 2 changes that are gonna be made to that consent judgment, are you in agreement with it?
yes,
Do you have any questions about it?
no,
And do you understand that spousal support is being waived? You can never go after spousal support from your wife in the future.
yes.
Um, No further questions.
Thank you. Mr. Vernon, did you have any questions?
I have one question. I can either ask him or her. It doesn't matter. Mr. Hull, has there been a breakdown in the marriage to the extent that the purposes and goals of matrimony can no longer be achieved?
Yeah.
Yes.
Yes,
And is reconciliation possible?
no,
I have no other questions.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. And I'm assuming, Mr. Vernon, that either you or Ms. Massey will submit the judgment.
We hope to have that to the court today.
Okay, thank you. That's all for today. Ms. Massey, you and your client are free to disconnect at this time.
Thank you.
thank you.
Thank you. Thank you, Your Honor.
Let's see right now. So far, so. Okay, Mr. Menkes, are you appearing on the Bodett versus Reedy case?
I am, Your Honor, on behalf of David Reedy.
Okay. And Mr. Frio?
I am here also on behalf of, I appeared on behalf of 2 Reedy defendants that were in the caption more recently.
Okay, very good. And then Mr. Bodett, are you able to hear me okay? I do need you to unmute, please.
I've got you now. Apologize.
Thank you. All right, well, we're on the record. Again, this is Alan and Sandy Bodett versus William and David Reedy. This is case number 2311562. We have both counsel here on behalf of the defendants. Mr. Bodett, you're proceeding without counsel, is that correct?
That's correct.
Okay. And is Sandy Bodett present with you?
She is not. She's here in the house, but she's not present with me directly next to me. My name was the only one on the appearance information that we received.
Okay. All right. This is set for a status conference here today. Most recently, the court granted a motion on behalf of plaintiff's counsel to withdraw from the case. And Mr. Bodett, is it your intention to proceed on your own?
As of this point, yes. Yes, Your Honor.
Okay. All right. And from the defendant's side, Mr. Friel or Mr. Menkes, can either of you give me an update from your side of things on where things stand and what needs to go forward to get this matter resolved?
Judge, there's virtually been no discovery because of prior counsel's motion to withdraw. In fact, the initial disclosures haven't even been exchanged at this point. So this case is definitely in its infancy.
Okay. Is there a particular period of time that defendants would like to request for discovery?
Standard 120 days.
Okay, Mr. Bodett, is there any particular period of time that you would like to request for discovery?
Actually, at this point, Judge, because I just received this a week ago, I'm not actually, this was received through my former counsel. Obviously, it was delayed, and I've just received it a week ago. I'm not exactly sure what it is based on the very limited information that I did get from my counsel as this has been going on, and I do say limited. I'm not exactly sure what this pertains to any longer.
Well, I mean, you're the plaintiff here. You and Ms. Bodett are the plaintiffs. So I guess you guys need to decide whether you want to go forward with your lawsuit. But you know, you're the ones that filed the lawsuit, so you guys are going to have the burden of going forward with this if that's the way you decide.
I understand that. I'm based on the limited information that I was getting from my counsel. I don't even have documentation showing what it was that we were going forward with litigation on. And I'm being 100% serious with that. The back and forth with that group was very, very limited. Unless it came to charging me for items that they did, which was very upfront, obviously. But at this point, you know, I'm of the thought that I'm, you know, pretty much I've lost interest in pursuing things any further. Now, if I knew exactly what it was that my counsel had essentially tried to go after, I may feel slightly different than that. But at this point, with what I've got in front of me that I received a week ago, it doesn't really give me an idea of where they were at, what they did, and how far along they were.
All right. I guess this is what I would say then. I'm going to, first of all, I'm going to set discovery to remain open for 120 days, just as a matter of course. I'm going to set this for another status conference by Zoom in 30 days. At that point, Mr. Bodett, you know, I guess I'm going to be asking you whether you're going to dismiss this case for a final decision as to whether you're going to dismiss the case or whether you're going to proceed. And you'll need to make that determination. The only thing I would say, and I would caution you, and you may want to, consider getting counsel to make this decision. That's up to you. But if you elect to not dismiss the action, but then you don't really do anything to move it forward as the plaintiff, the defendants are going to continue to incur attorney fees to have their lawyers represent them, and they may be in a position at some point to ask the court to order that you pay for attorney fees because you're continuing a lawsuit and then not doing anything to prosecute it. So
Understood.
That's going to be a decision for you to make. But I'm willing to give you some time to make that determination to get the information that you need.
Understood. Thank you, Judge.
Having said that, that's the way I want to move forward. Mr. Menkes or Mr. Friel, did either of you want to make any kind of record to an objection to the court doing that?
No objections, Your Honor.
No, Your Honor, I agree with that.
Okay. All right. So the court will send out notice of the date and time of that hearing in 30 days. And we'll go forward from there. Mr. Bodett, do you have any questions?
Not today, Judge. Thank you.
Mr. Menkes or Mr. Friel?
All set here.
Happy holidays to everybody.
You as well.
Okay. Thank you. All parties are free to disconnect on this file.
Thank you.
Thank you.
Mr. Kuhn, I'm going to have you come back up to the podium there. Are you able to hear me okay, Mr. Kuhn?
Yeah.
Okay, so I just want to explain a couple of things to you. I have an obligation to ask you certain questions to make sure that you understand what's happening with your case. And that's why I'm asking you whether you understand that you have the right to have an attorney and that you would have the right to have one appointed if you couldn't afford one. I'm just trying to make sure that you understand your rights, and it's my job to explain those rights to you. I'm not asking you to give up any rights. You're not putting yourself in any kind of legal danger by answering these questions. I'm just trying to find out if you understand what your rights are and how we're going to go forward, so that I know that you're knowingly and voluntarily choosing not to have an attorney to represent you. And if you don't answer these questions that I'm asking you, it impedes my ability to proceed with the hearing in the way that I'm required to under the law. You understand that?
How to answer that. All I know is I was told, when I've read and stuff, that I'm here in special appearance.
What do you think that means?
I'm not contracting. If there's no corpus electi, how could there be a crime?
Okay. Do you know what that even means?
There's no injured party.
What you're saying?
If there's no injured party, where is the crime?
Okay, well, first of all, a jury found you guilty, right?
And that, well, see, I'm stepping
And
into.
they found you guilty of assaulting or resisting or obstructing two police officers. Right, that's what happened.
I'm here on special appearance.
Okay. If you continue to refuse to answer my very simple questions just about whether you understand what's happening, and if you continue to just give me that answer, which doesn't make any sense and doesn't have any legal effect, no matter what you've read or what other people have told you, then you're impeding my ability to proceed in the way that I need to under the law. And if you continue to do that, my only option is to impose a sanction on you until you do answer my questions. And what that means is that I'm going to find you in direct contempt for impeding the function of the court by refusing to answer very simple questions. And I'm going to put you in jail for 30 days. And if at any point during that jail stay, you decide that you will answer these very simple questions, then we'll come back into court immediately and we'll take care of the sentencing. But those are going to be your options, because I'm not gonna have you just.
Okay, well, thank you for clearing that up.
So it's your choice. You can answer my questions or you
An
can.
attorney, but the attorney I had absolutely did nothing.
Okay, we're past that point. What we're here for today is the sentencing hearing, because you've been convicted, you've been found guilty by a jury of your peers. And so we're here for sentencing. So we're not here to talk about what did or didn't happen with your lawyer before. I'm trying to find out if you understand that you have the right to hire your own lawyer, or if you can't afford one, that one will be appointed for you. Do you understand that you have that right?
Yes.
Okay. And you understand that proceeding without a lawyer has certain risks. Do you understand that?
But I obviously can't afford an attorney.
Okay.
And the one I had, again, didn't do a dang thing because the ticket should have never been split.
Okay. Do you want to
That was my
request?
argument to begin with.
Do you want to request a different attorney to be appointed?
Actually, yes.
You did. Okay. All right. So you did previously qualify. So I find that you continue to qualify for court appointed attorney. Court is going to appoint one for you, and we'll reset this hearing for my next available date. Okay.
Am I going back to jail or can I go home?
No, you're going back to jail until we can have the hearing.
I've already had 3 weeks in jail, sir.
And you made that choice by refusing to comply with the pre-sentence process. That was your choice. You're just facing the consequences for your own choices. And if you have people advising you to take this ridiculous stand and make these statements that don't mean anything to the court, they're giving you really bad advice. And they're not the ones paying for that advice, you are. And I think you need to start listening to a lawyer who actually knows something about the law and not what you read on the internet or what people tell you because they don't know. And you're taking their advice and you're paying the consequence for their bad advice. They're out doing what they want to do. You're the one who's in here in jail. So I would suggest that you start listening to a real lawyer and not what you read on the internet or what people are telling you who really don't know what they're talking about. So that's the way we're going to proceed. We'll appoint an attorney to represent you at the next hearing. And
when will
your
that
bond
be?
is going to continue to be revoked until that time. What's that?
And when will that be?
As soon as I can get it on the schedule, probably about 2 weeks. Let's hope any record.
No, I'll let Mr. Thompson know that he was a side counsel so we can get somebody in there quickly.
All right, that's all for this hearing today. Our next hearing is set for 11, so we'll be in recess until that. Is Ms. Orr present?
Yes, I am.
Ma'am, you come right up to this table here.
Is it okay if I bring my grandson?
No, and it's really not appropriate.
Okay, I apologize. I don't have a babysitter, Your Honor. All my family lives downstairs.
Tell you what, young fella, how about you and I go outside and look at the books out there?
Thank you so much.
You're very
Thank you.
welcome.
Thank you. I thank you.
We got Mr. Sir, come right up to this table, please. we're on the record now in Orr versus Olson. This is case number 2411700. Both parties are present here today. This is a personal protection order matter. Or you were granted a personal protection order by the court back in June. Mr. Olson, you filed a motion to ask to have that terminated. Is that correct? Yes. And Ms. Orr, are you asking this order to remain in place?
Yes, I am, Your Honor.
Okay. So what we're going to do, I'm going to place you both under oath, and I'm going to give you both an opportunity to tell me about what's going on this, or you can tell me why you think the order needs to stay in place. Mr. Olson, you can tell me why you think it should be terminated. We are recording this, we're making a record of it, so I'll ask that the two of you don't interrupt each other when you're talking. Please don't make any comments directed at each other across the way. If you have any comments, then they should be directed to me up here at the bench. I will give both of you a reasonable opportunity to tell me what you think I need to know. If I feel that you're going off topic or getting in areas that aren't relevant to me, I may stop you and try to redirect you, but otherwise, I'll do my best not to interrupt you. I'll ask that you don't interrupt me when I'm talking so that we can make a clear record. Ms. Orr, because you are asking the court to keep this order in place, you'll have an opportunity to go first. And then Mr. Olson, I'll have you tell me what you think I need to know. And then Ms. Orr, because you have the burden of proving to the court that this should stay in place, I'll give you an opportunity to respond to anything that Mr. Olson has said.
Okay.
The court has to find that there is evidence by a preponderance standard to keep this order in place. That means 51%, 49%, just barely tipping the scales one way or the other. So that's the level of proof that I'm looking for.
Okay.
Or do you have any questions about how we're going to?
No, I do not, Your Honor.
Mr. Olson, do you have any questions? No, sir. Oh, can you both raise your right hands? Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Your hands. So Ms. Olson or Ms. Orr, I understand based on.
Would you like me to stand, Your Honor? Or?
You guys are good. Just
okay.
Stay seated. Okay. But thank you. I understand based on your petition that this has primarily to do with issues regarding the road and what happened.
Yes, continuous harassment against Mr. Olson towards me and my grandson in the car. I've been raising my grandson. Okay, sorry, I apologize.
Okay. How this is all.
Okay.
Kind of the lay of the land here.
Okay.
So, do you live on a public road or is it a private road?
It is public.
Public. Okay. And how many houses are on that?
Just mine. Dan next door, which is it's his vacation home, and then Mark all the way down at the very end.
Who's Mark?
He is just a neighbor.
Oh, and where does Mr. Olson live?
He lives at the end of Colville.
Is that the road that you live on?
No, I live on Godfrey Road.
Okay. All right. So
like a quarter mile, maybe a little less than a quarter mile away. Far, very far.
Does your road end at Colville?
No, it well, it swerves around into Colville, but then Godfrey can go back into Mathis too.
Okay. And it's a dirt road, it looks like.
Yes, all the roads are dirt.
Kind of narrow.
Yes. Now on certain roads you can fit 2 cars, and on one road you can only fit 1.
Okay. All right. So tell me about, obviously in June you came to get this personal protection order. So tell me specifically what happened at that time that led you to come and get this order.
Okay, we've noticed him driving both ways onto our property. And then I put rocks out, and he was going further up. He almost hit my dog. I got a little 5-pound long-haired Chihuahua. He almost hit her. My grandson rides his bike up and down. He's going across the driveway. I mean, like all the way, both ways. And he's going further up. And he almost hit my dog. I'm worried he's going to hit my grandson.
Okay.
I mean, I'm deathly afraid.
Okay. And then you put in your petition, you've had some issues when you're driving down
Mathis, him coming towards me in this way. he stays right towards the middle and pushes me off. So he pushes me off. One time in 22, he swerved into us. It was me, my husband at the time, and our grandson, which he was 3 at the time. That's when my husband at the time called the police and the police came out. I called twice in 23 when he was doing that to me. You know, I got my grandson in the car. I'm worried about my safety, my grandson's safety. And the police, all they do is tell me, well, we can talk to him, but file a PPO in order. And that's all they keep telling me every time I go down there, every time I call. And I did call on the 14th, and a police officer was supposed to come out, but they got too busy. But then I went up there that following Monday, and they, you know, took copies of all the pictures and told me to go file a PP. That's all they can do. It's a PPO order, which doesn't make sense because he has a white vehicle that he's been driving every day down the road. And it's only him and Mark that drive the road because he stops everybody and tells them it's a private road. Everyone on Colville is not allowed to go down there.
Okay. Why do you think that this kind of stuff is happening?
I don't have a clue. I've never talked to this man. I think because my husband at the time talked to the neighbors at the corner and he didn't like it. And because they don't like the guys because it's their vacation place. And, they go out there and they, have fun. It's their vacation home. And my husband at the time was talking to him. He knows I'm alone. I'm scared. I had to get outdoor cameras, indoor cameras, security. I'm scared. My safety, my grandson's safety, I'm alone now. And, when it was Paul living there, Paul was nice. He's the original owner of the home and he passed away. I lost my son and my son was on life support in June. No, this past May. And I'm going back and forth dealing with that and then dealing with his harassment. I can't take the emotional stress anymore. I can't. And I can't, my grandson wants to go for a ride on his bike and us walk down the street. I can't do that. I'm worried he's going to hit us. He's so focused on harassing me that he sees nobody. On June 14th, Officer Stern was in our driveway. He was going across our grass. He didn't even see the officer that was parked in the middle, Crawford County police car in our driveway. That's how focused he was on harassing me. And I don't know why. And if there isn't a PPO order, I have no protection, even with, but he's not going to listen with or without it. The police have told them the one time Officer Stern had told them, he just doesn't care. And I got to worry about my grandson's safety.
Okay, thank you.
Okay, thank you.
Mr. Olson, are you driving onto her property?
No, sir, I'm not. And I can prove it here today. My property survey. These red posts out in their yard are actually their corner markers. They line up with my north boundary, which is their south boundary. So, and then I can show you pictures on Mathis Road where they've been driving around the holes on gas line property. I can show you pictures from South Cobell Road that people drive around the holes on grass. So their property is, until they have it surveyed, they don't own to the edge of the road just because they planted grass to the road. I paid a lot of money to keep the South Cobell fixed up. I probably got $3-4 grand into it. Dan Jolly has a lot of money into it as well. Herb, we used to own Orr's place before that. He put money into it, but within the last year, these people have been down there and they've been leaving their tracks in Orr's driveway. They've been deliberately tearing that road up.
Okay, well, none of that would give you the right to
No, I'm not
endanger
wrong.
their dog or their child, right?
I have not seen a child. There's no pictures of a child or a dog in David. That's hearsay. That's like me. I'm driving down South Cobell, or down Mathis. They get out in front of me and they said fishtail it, throw dust and rocks all over my car. So, I mean, and here's her husband. Actually, must have choked her last summer because.
Okay, I'm just gonna stop you because one thing that you need to understand is you haven't asked for any kind of order against her.
No,
We're
sir,
here,
I
let me,
have- I've
let me,
never-
let
I
me
haven't
finish.
been to court.
Please let me finish so that I can explain to you what I need to know, okay? She's alleging that you've done these things to her, right?
I have done nothing.
So what I need to find out is whether those things actually occurred or not, because that might be a basis for personal protection. So I need to know from you what evidence you have that what she's saying is not true, that you didn't try to, hit her dog or her child, or that you're not moving out of the way to allow them to drive past you. Are any of those things occurring?
No, they're not.
Why would she make that up?
Here they said that I was snow blowing, it's right on the order that I was snow blowing. Here I'm a handicapped person, I don't run a snow blower. So, I mean, they're tormenting me just the same. So I don't so all there, a girl with a white car, a girl was driving it, I was in the passenger seat. I guess, her and her friend were screaming vulgar stuff at us when we drive by. I have hearing aids, I can't hear that stuff at all. I mean, she said they were screaming a whole bunch of stuff at us, and we were on the road, so that's who's tormenting.
Why do you think that this circumstance is happening? Why do you think there's this problem?
I called the cops on over there last summer, and since then, he's just been, a campaign's been tearing up the road. I could drive in there with my Mustang last year, I can't do that this year. They've got pictures of all the holes on Mathis Road. The Officer Stern said he bottomed out when he came down Cobell from my house. So they're ORV trails, and we can't get anybody to get the ORVs off.
Okay.
I've been to county police, I've been to the commissioner here in town in this building, I've been to the DNR. I've been to everybody. I've been to the township board trying to get these, the last time we went to court was in 07, that was before the invention of side-by-sides come out. They really tear up the lands. We can't even have it, I can't even get first responders down South Cobell at my house. When I had to take Paul and get him picked up by an ambulance, I had to take him out to 7 Mile and Military just so I get an ambulance. Because South Cobell is 3 months out of the year, you can't make it down.
Okay, so, but what does any of that have to do with whether or not you're driving onto her property or endangering her dog or her?
I haven't seen a picture of the dog yet, and any of those pictures of me, and that's a part. Here's my survey, that shows it out this corner.
Okay, but what about right in front of her house? Are you driving onto her property right in front of her house?
Here.
Are you doing that?
No, I'm not, I'm here showing.
What about the picture that she has that shows your?
And I got pictures that show their property line, and I'm well without it.
So your view is as long as you're not going over the property line, you can drive as far as over as you want.
I can, yeah, I gotta avoid the holes, my back's fucking shot. Excuse me for my language. Yeah, my back's shot, I can't sit here driving over these holes.
Oh, yeah.
When they're deliberately tearing them into them.
Okay. And you're saying that if the dog is out there, the grandchild is out there, you're not
seeing them out there.
You're not endangering them when you.
The only time I see the grandchild out there is when he's out there walking with this guy here.
Okay, but you're saying you've never endangered the dog or the grandchild by driving out?
No. I haven't even been pulled over since, I want to say 08, it's for table. I do not drive. I drive down those roads 12 miles an hour max. Not in a hurry.
As I said, or you have a chance to respond, is there anything that you wanted to say?
Yes, Your Honor, I don't have any ATVs or any of those driving things. I don't even drive down Colville except for twice because of our mail is on the main road. So I've only drove down there twice. So him blaming me on his road, I've never been down there. When Paul lived there, we used to walk down there, me and my grandson. But since Paul's been gone for the last 3 years, I won't go that way ever, not even walking. Yeah, I have to go out Mathis. How am I supposed to get out? You know, I only have a car. I don't have no ATVs. We don't have any riding things, nothing. And I do have pictures of my dog on the road, on our driveway. Our dog, the day he came by, which he is on way above our property line, Your Honor. I do have pictures in color if you would like to see them.
No, I think I understand.
Okay. You know, he's so focused, he didn't even see the police car in the driveway. Police car told him it was against the law to do that. But, you know, it just doesn't care. And, you know, I'm worried my grandson's gonna get hit. I'm scared to go for a walk with him. We used to go for walks down the other way, but if he's coming down the road, he's gonna end up hitting us. Because he's so focused on harassing me. I've never even talked to this man. I used to wave to Paul, you know, I've lived there way before. This Mr. Olson lived there. And ever since he moved in, it's been crazy. I've had neighbors come to me. I know this is off topic and I apologize. Come to me.
I can't have you tell me.
Okay, all right, okay.
I just need to focus on what's going on.
Okay, all right, okay. I'll save that for the other court.
All right, give me a couple minutes here and I'll
Yeah.
We're not meeting.
All right, Wexford County, are you able to hear me?
Yes, Your Honor.
We are, Your Honor.
Thank you. 1 second, I'm just gonna adjust the camera here. Okay. All right. We're on the record now. This is Wexford County case, People versus Shamewall. And this is, 1 second here. Okay, Wexford County file number 23-13713FH. This court is sitting on this matter by assignment. This is set for a final status conference and plea cutoff hearing here today. If I could just have both counsel put your appearances on, please.
Morning, Your Honor. Corey Wiggins on behalf of the people. I'm Jeff Harrison. I'm here on behalf of Mr. Shamewall. He is also present and is seated next to me at the table.
Okay, thank you. We have this currently set for trial to begin on July 30th. Mr. Harrison, have you had a chance to speak with your client about how he wants to proceed?
We have had that opportunity, Your Honor, and at this point, there is no proposed resolution to the matter. We would have it continue to be set for trial. I'm not sure of your preference in this regard, Your Honor, with regard to a plea cutoff. You did mention it. I would seek some clarification as to what you meant.
Okay, typically I consider the final status conference prior to trial as the plea cutoff. If you know, I don't have an objection to, you know, extending that a little bit if counsel wasn't prepared for that today. I get it. I mean, I know you may not be familiar with my standard practice.
It's the same rule, if you will, that we are obligated to observe in Wexford County for what it's worth.
Okay, all right. We'll plan on proceeding with the trial on July 30th. Have the people submitted their proposed jury instructions and a verdict form yet?
We have not, Your Honor. I apologize. I missed that in your scheduling order. We will have that done by mid next week.
Okay.
For you, Your Honor.
And I will make a similar submission forthwith.
Yeah, so defense counsel, I don't typically require defense counsel to submit the full text instructions, only any different or additional instructions or objections that they have to any of the prosecutor's instructions.
That'll be fine, Your Honor. Thank you.
Okay, and then I typically have the parties present and ready to go by 8:30 on the morning of trial. We go right into voir dire and jury selection, and then once we have a jury selected, I go right into opening statements and presentation of evidence, so counsel can be prepared themselves in with their witnesses. On behalf of the people, are there any matters that you anticipate we're going to need to address before beginning trial?
Not that I'm aware of as of now, Your Honor.
Okay, how about the defense?
I have the same sort of response, Your Honor. I don't anticipate there being any issues.
Okay. All right. Do the people have anything else that we need to address here today that you want to raise?
I do not, Your Honor.
Okay. Anything further from the defense?
I suppose, Your Honor, I would ask for, if we did come to some resolution, I would ask for the ability just to approach you and take your temperature on whether or not you'd be willing to implement it.
I would say that, you know, again, I would allow, let's put it this way, I'm gonna set the cutoff then at 14 days prior to trial.
Okay.
I don't wanna, I'm very unlikely to accept any plea offers or plea agreements after that time, simply because, particularly the added complications with the court sitting in this file by assignment. So 14 days from the trial date will be the plea cutoff.
That's perfect, Judge. Thank you.
I'll put that into, I'm gonna send out a status conference order reflecting what we've discussed today, and that'll be indicated in the status conference order as well.
Again, thank you. I appreciate that.
Okay, thank you. That's all I have for today, and the court's gonna go ahead and disconnect at this time.
Thank you. Thank you.